Hello everyone, today we're going to discuss about section 167 of the CrPC that deals with procedure when investigation cannot be completed in 24 hours. This section tells about remand and bail. So firstly, whenever a person is arrested or detained in the custody and it appears that the investigation cannot be completed within the 24 hours as contemplated under section 57, and there are grounds for believing that the accusation or the information against the accused is well founded, then the OIC or officer in charge of the police station, or IO, that is investigating officer, who is not below the rank of SI, sub inspector, he shall forthwith transmit to the nearest judicial magistrate. Transmit what? A copy of the entries in diary relating to the case, that is case diary, and also forward the accused to such magistrate. Then what is the procedure? The magistrate to whom the accused is forwarded, whether he has the jurisdiction or not to try the case, he may from time to time authorize the detention of the accused in such custody as he thinks fit. Custody means here police custody or judicial custody, both. He can authorize the detention whether in police custody or also in judicial custody for a term not exceeding 15 days in whole. The custody period, or he will be sending the accused to remand, it will not exceed the period of 15 days. Then if such magistrate has no jurisdiction to try the case or commit for trial, if he has no jurisdiction to try the case or commit for trial and considers the detention unnecessary, further detention unnecessary, then he may order the accused to be forwarded to a magistrate having such jurisdiction. The police custody given under this section will be maximum 15 days from the date of the custody, whereas judicial custody may extend up to 90 days or 60 days as the case may be. In the said period of 15 days, the detaining authority may be changed, that is police to judicial, judicial to police, but that period shall not exceed 15 days in the whole. So it can be summed up like this: magistrate, whether have jurisdiction or not, he can authorize the detention up to 15 days max, and magistrate not having jurisdiction will forward to the magistrate having jurisdiction even further detention is necessary. When further detention is necessary, the custody will always be judicial, as the maximum days for custody of police is 15 days. So there is a provision to section 167 clause 2, that is, if there is beyond 15 days period detention is necessary, then magistrate may authorize the detention of the accused person otherwise than in police custody, that means to judicial custody, if satisfied adequate grounds are existing, that is up to 90 days maximum in case of an offense punishable with death, imprisoned for life, or up to 10 years, and maximum up to 60 days in case of any other offense. The said period of 90 days is actually 120 days in the state of Odisha amendment. When the said period of 90 days or 60 days is expired, then the accused shall be released on bail. He will be getting a right to be released on bail if he is prepared to do and does furnish bail. If he is not prepared and does not furnish bail, he shall not be released on bail, and it will be deemed to be released under the provisions of chapter 33, which is regarding bail. Another point, if a person is transferred from police to judicial custody, then the number of days he served in the police custody will be deducted from the total time of remand. So suppose magistrate order remand of 3 days to the accused to police custody, then the accused is transferred to the judicial custody. Now he can serve the maximum period of remand, that is 15 minus 3, 12 days. So in the 15 days period, he can be ordered remand to the judicial or police custody. Both will be added, and that shall not exceed 15 days. Whereas in case of further detention, it will be only judicial custody beyond the period of 15 days. That is up to 90 days or 60 days as the case may be. There have been differing views with regard to this computation of the period of 90 or 60 days as the case may be. While one view preferred to count the period from the day of arrest, the other view held that it should be counted from the day of remand by the magistrate. But further, Supreme Court held that in a case, the period shall be counted from the day of remand by the magistrate and not from the day of arrest. Suppose within 90 days no investigation has been completed or no charge sheet has been filed, then the accused will be entitled to bail if he is prepared and furnishing bail. Suppose in a case where the charge sheet has been filed but no cognizance has been taken by the magistrate, then accused shall not be entitled for bail, because this section talks about only investigation and not cognizance. The period of investigation would come to an end the moment the police report or the charge sheet is submitted. The question of bail arises when the police report is not submitted within the stipulated period of 60 or 90 days. Now the clause B under subsection 2. It says accused should be produced before the magistrate in person for the first time for authorizing detention to police custody and subsequently every time till he remains in the police custody. And in authorizing detention to judicial custody, the accused may be produced in person or through electronic video linkage. So it can be summed up as such: in authorizing detention to police custody, the accused shall be produced before the magistrate in person, whereas authorizing detention to judicial custody, he may be produced either in person or through electronic video linkage. Clause C says no judicial magistrate second class who is not specially empowered by the High Court shall authorize detention to police custody. Now see the explanation. The period stipulated in A has expired, that is 60 days or 90 days. The accused shall be detained in custody as long as he does not furnish bail. When he is prepared and ready to furnish bail, then only he is entitled to be released on bail. So explanation 2 says if any question arises whether an accused person was produced before the magistrate as required under clause B, the production of the accused person may be proved by his signature on the order authorizing detention or by the order certified by the magistrate as to production of the accused person through the medium of electronic video linkage, as the case may be. Another proviso in this subsection that says women under 18 years of age shall be ordered detention in the custody of remand home or social institution and not to any police or judicial custody. So subsection 2A is as such given in subsection 1. Subsection 1 deals with judicial magistrate, subsection 2A deals with executive magistrate, and here the total period will not exceed the 7 days. The executive magistrate shall authorize the detention of period not exceeding 7 days in the whole, and the period remanded by the executive magistrate to be included in computing the period of 60 days or 90 days, as the case may be. If before the expiry of the said period above, the executive magistrate will transmit the nearest judicial magistrate, what he will transmit? The records of the case plus the copy of the entries in the diary which was transmitted to him or given to him by the officer in charge or the investigating officer. Suppose executive magistrate remanded for 3 days, then the accused was transmitted to the judicial magistrate. Now judicial magistrate can remand for how much days? Judicial magistrate can remand for the maximum 15 days. As he has already undergone the remand of 3 days, then judicial magistrate can remand for 15 minus 3, that is 12 days. Subsection 3 of section 167 says a magistrate authorizing the detention in police custody shall record his reasons for in writing. That means it is a speaking order. Subsection 4 says any magistrate other than the chief judicial magistrate shall forward a copy of his order with reasons to the CJM. 167 clause 5 says about stopping of investigation. If in a summons case, if the investigation is not concluded within 6 months from the date of arrest, then the magistrate shall make an order stopping further investigation unless the investigating officer satisfies that for special reasons and interest of justice the continuation of the investigation is necessary. So 167 clause 6 says where an order of stopping the investigation has been made, then the application has to be made to the sessions judge, and if sessions judge is satisfied that further investigation ought to be made, then the sessions judge may vacate the order of stopping the investigation and direct further investigation subject to the bail and other matters. So this is all about remand and bail under the section 167. Hope you all will like it.